Hi, everyone. This is constitutional attorney Catherine Henry. I don't even know how to start this video. This video is actually going to be pretty short. Hoping to be able to do a longer video a little bit later on. Right now, I just wanted to at least provide somewhat of an update, something quick to let you know, number one, that the Election Day Allegan County case is in fact still going, and where we're at with things in that case. The Election Day case is definitely still going. And we had a settlement conference today, and we went on the record in front of the judge, and he decided on some things today as well. And we are second in line to go to trial on next Wednesday, July 21st, first thing in the morning. I don't remember if it's 8 or 9, but what trial or what case you might be asking if you've joined a little bit more recently. I wrote a constitutional amendment petition, the Restore Freedom Initiative, last year, and it was meant to restore our freedom and to stop the government from the overreach and the ridiculousness that came about with their response to COVID-19. And, you know, obviously, the petition was also going to do much more than that. It was going to stop anything like this from ever happening again. Well, I was also the lead attorney for the entire initiative, working with the thousands of volunteers we had across the entire state. And on Election Day, well, we definitely needed signatures. We were at the polls. We had thousands of volunteers all across the state collecting signatures at the polls. State law only requires you to be 100 feet away from the door of the poll when you are campaigning in any way for a candidate, for a constitutional amendment, for just a statutory referendum or initiative. Those are the kind that Stand Up Michigan had been doing with Unlock Michigan. All of those, same rule applies. You just have to be 100 feet away from the door of the precinct. Well, I had a volunteer call me on Election Day. She was definitely well more than 100 feet away from the door, and yet a sheriff's deputy was saying she had to leave, otherwise she would be arrested for trespassing. And this was at the request of the then township clerk, who the deputy said, well, the township clerk is the owner of this property, and so she can determine if she doesn't want you here. She said, you have to go. I told him I would be on my way in person to talk with him, as we were clearly at odds about what the law actually said. I read it over the phone. He indicated that was the whole statute, that I was missing another few sentences, which I was not. So I said, you know what, I will just print it, bring it down, and we will discuss it. And he said, okay, I'll be waiting for you. When I got there, he was not there. He had to respond to another call. He ended up showing up, and a couple of minutes later had 2 other deputies respond as well. And they all refused to talk with me about the law at all, in any shape, way, or form. The township clerk also didn't want to talk about the law, didn't want to talk about the Constitution, didn't even want to talk about the actual, what they called is an ordinance, is actually a township resolution, which cannot be used to regulate people. And the fact that the resolution itself doesn't even say that I wasn't allowed to be there. In fact, it said, as long as somebody is abiding by the 100-foot requirement, that they can be there. At any rate, within a few minutes, really, of having the 3 of them all arrive and refusing to talk with me, they violently arrested me, dragging me away. I ended up with bruises and contusions and cuts. I was bleeding. I was told that my daughter was being taken by CPS. I was not allowed to call my husband to come and get her. or to have anybody else that I knew on the scene to come in or to take her. I was told my vehicle was being towed, and yeah. So at any rate, we were, especially my daughter, who was 6 at the time, and myself, we were thoroughly scarred by the incident, and yet I ended up being charged with supposedly trespassing on government property open to the general public. I eagerly awaited the deputy to file the documents so that I could file my motion to dismiss. He didn't do so for 8 days afterwards, 9 days actually, and then I was denied my initial request to have a hearing right away. I was then allowed to have, finally, my hearing, but it was only after arraignment, and it had to be another 3 or 4 weeks after that. So even though at the beginning of November, I was asking the court for a date to have my motion to dismiss the charges, which I am allowed to under all state rules, court rules and state laws, and you name it, I was told by the court staff I wasn't allowed to get that date until much later, and so they made me wait 2 months, no, 3 months, till February 4th. At that time, I was, I wasn't allowed an attorney in the courtroom with me, which even though I am an attorney, I'm allowed an attorney in the courtroom. I was not allowed to have anyone present in the courtroom, which is blatantly violating MCL 600, I believe it's .1420, that says all public hearings in the state are to be open to the public, with 3 exceptions that have absolutely nothing to do with what was happening in this case. And yet the judge did not allow me anyone in the courtroom, did not accommodate my ADA request. Even behind plexiglass was wearing a mask, and the prosecutor had a mask, and that was different than the first hearing I had been at. Did not really allow me any rights. In fact, did not rule on the motion itself, on the substance of my motion, but rather, in fact, told me that I did not have a right, and the prosecutor also argued this, I did not have a right to raise any legal issues. I was only allowed to have my day in front of a jury, that all the issues would be resolved by the jury. The judge ordered that, the prosecuting attorney argued that, and so I started my journey of appeals with the Michigan Court of Appeal, well, with the Allegan Circuit Court, and then the Court of Appeals, and hadn't yet made it to the Supreme Court for appeals, but anyway, the district court and the circuit court ended up ruling that I have no right to ADA accommodations except for whatever the court wants to force upon me. So if the court determined a wheelchair would be helpful to my hearing disability, I would have to try to use that, and that's it, which is not how the law works or common sense. It's also not how the Supreme Court has indicated courts need to work. They also indicated there was no problem with me not having an attorney, and that there was no problem that the hearing was shut to the public, even though there's been enough Supreme Court precedent to know that that's not okay for them to do. They said that like I said, I had no right to raise the issues, that no defendant ever, especially in a misdemeanor case, has any right to raise any legal defenses before the trial, which is stupid. And said that my motion to dismiss was not proper because you can only do one of those in a civil case. Funny thing is, the example document that I submitted to the court showing how to do one of these, prepare one of these motions, and it was actually authored in part by Chief Justice Bridget McCormick of the Michigan Supreme Court, and it referenced the exact court rules that I was using. So my appeal began and was going, and the Court of Appeals on both sides eventually came back saying not that I was wrong, not that I got the law wrong or that the prosecutor or lower judges got it right, but only in one sentence to say, we're just not convinced we need to handle this case right now. So fast forward to, all through that time as well, I had been requesting discovery in the case. I wanted to know their witnesses and their exhibits and, what jury instructions they planned on trying to introduce, or basically anything. I wanted evidence. I wanted the police reports. I wanted the dispatch communications unredacted. And we had 2 full hearings on that in April. And I even got an order signed by the judge that said they had to give me those things. Some of them later on, because the trial, he was moving to July, but some of them were ordered to be produced that Friday in April. And most of those items remain undisclosed. So today we had a hearing in Allegan County, and the prosecutor has still yet to disclose quite a bit of that information. And the judge essentially ruled that for much of it, I am not entitled to it because he didn't think it was relevant for me to have a defense. And the other stuff he said that I should raise the morning of trial. Not sure how raising these issues of me not having the evidence the morning of trial is going to do any good, because should the prosecutor then give me the information at trial, I have no opportunity to review the information, to prepare, to talk to witnesses or get rebuttal witnesses. I am totally precluded from doing any of that trial prep. So, the prosecutor also argued that she said there were legal issues that needed to be decided because they were a matter of law that the judge had to decide, and the jury was not allowed to decide, which is actually the entirety of the bulk of my argument to the Court of Appeals and the lower courts, saying that these are legal issues I was raising. But the prosecution had been arguing all along, it doesn't matter, you don't get to raise those issues. So today, when it was to her benefit, she said, oh no, Judge, you need to decide these legal issues. One of them being that Catherine thinks that she is, that she was entitled to be on the property, and you should stop her from introducing any evidence that she was entitled to be on the property or that she thought she was entitled. And the judge pretty much agreed and did not allow me very much argument on that point at all. I tried to say that it's her job to prove beyond a reasonable doubt with trespassing that I had the intent, according to the statute, I believe it's 750.552, that I had the intent to remain on the property of another without authority after the person with authority has told me I have to leave. I would think if they have to prove intent, then I can present a defense that goes to my intent and my reasonable beliefs. Quite frankly, they don't even have to be reasonable. If I believed it to be true, I don't have the intent necessary to commit the crime. So regardless of the fact that I actually have the legal right to be there, and the volunteers that were there that day had the legal right to be there. In fact, everyone has the legal right to be on property open to the general public and cannot ever receive a trespass citation or criminal charges. Despite all that, even if I was inaccurate in making that assumption or thinking that, if I sincerely believed that, then I did not have the intent to unlawfully remain on the land of another. And so that is definitely essential to my defense. But the judge, I don't know, as a whirlwind, it seemed that he may have, in fact, said I really don't get to introduce evidence to that at all. The prosecution also argued that, I also indicated that I had the legal right to be on the property because I was an attorney representing the people who were there collecting the signatures. And as an attorney, as any public official, and state law says that attorneys are a member of the public body, the State Bar of Michigan. And so serving in that capacity, there's another state law that says that when you are serving in that official capacity, you cannot be arrested unless it is for treason or one of two other crimes that were not relevant here, none of which are trespassing. And literally the entire reason why I showed up is because I was representing people and the petition. And no one denies that I was there in my capacity as an attorney. But the judge didn't think that was relevant and said I can introduce some evidence about that, but he's not going to instruct them on what the law actually says on that point. Then the prosecutor also raised the argument that she claimed I started a Facebook event to get people to protest and wear shirts and hold signs with my name and restore freedom, and I'm trying to get people to riot and cause problems in front of the courthouse. I said I did not, and she said, well, I have proof. And I said, well, no, you don't, because I didn't do it. I've hardly been on social media. She continued that argument, but then also seemed to suggest that people don't have rights guaranteed by the First Amendment to protest or to, you know, stand in solidarity on any particular issue. She said it would be witness intimidation, jury intimidation for them to have to see that. And she then argued that because I have that link apparently gave that event gave a link to my website, and my website has documents from this case, public documents. She then argued that those public documents being on my website would make it unfair for trial, that it would be, I forget her exact wording, but substantially unfair to her and to the prosecution, that these public documents are in front of the public. There was much more that happened today. I was precluded from arguing anything on certain issues. I was precluded from arguing very much on other issues. And certainly to be told that I wasn't allowed to raise these issues in a motion to dismiss the case because I was not allowed to raise legal issues, only to have the prosecutor literally say the exact same language that I've said all along, that legal issues must be decided by a judge, not the jury. And then have the judge, he actually claimed that he had already determined and made the decision in a prior order that I did not have any of these legal rights, and that you cannot simply just be on property open to the general public, that the township is allowed to determine if you're allowed to be on their property or not, and especially on election day. That should be irrelevant because I wasn't charged with violating election laws. I was charged with violating a trespassing statute. And he totally ignored the fact that the Supreme Court has said in no uncertain terms, you cannot be charged with trespassing just by simply being present on property that is open to the general public, regardless of who owns it. It could be Costco, it could be Menards or Sam's Club or anything like that. You cannot be charged with trespassing on property that's open to the general public. No one can. It violates your right to equal protection. So, at any rate, to be told that I can't raise legal issues and I can't even raise legal defenses, and I'm going to be precluded from raising or introducing any evidence or testimony to support many of those arguments, it's quite shocking and it's disturbing. And if they can do that to me, if they're going to do that to someone who they know is an attorney, who is very well versed in the law and the Constitution and court rules and you name it, then who else are they going to do this to? Well, you. They're going to do it to you. I didn't commit a crime. So if you're sitting there saying to yourself, well, that's not going to happen to me. I mean, I've never committed a crime. Guess what? I have never done that either. I certainly didn't do what they said I did. So if you don't like the government telling you that you can't protest, or you can't be somewhere, or shoot, you can't even support a cause and collect signatures on election day outside of the 100 feet that is required, then you might want to consider finding that Facebook event that I think my friend Lori made, or Rachel or Lando, I'm not sure exactly who made that. But you might want to find that Facebook event. You might want to check it out. And we are only number 2 in the trial order, so there could be another trial that goes before me this Wednesday. But at this point, it is extremely likely that we will have the trial on next Wednesday in the Allegan County Courthouse in the District Court. And I'm pretty sure, you guys could double check me, but I'm pretty sure off the top of my head it is MCL 600.1420. That's MCL 600.1420 that requires and mandates that all hearings are to be open to the public. So if you want to be inside of the courtroom, then you have a right to do that. You can't cause a disturbance or a scene. You can't, blurt out or intimidate juries, or jurors, or anything of that nature. But you can be present. So a lot of you that are watching right now know that I've been fighting for our freedom from day one. I've been defending people who no one else would defend. I've been showing up when no one else would show up. And I'm continuing to do that, even though you've heard a lot less from me in the last couple months here. I'm fighting every day. And right now, we have things in our personal lives, as well as this case, that are devastating and a lot to deal with. And so I'm asking you to join me in this fight for freedom in whatever way you can, to show up, help donate funds so I can begin the next round of appeals. We've already spent thousands of dollars. I don't even know the total. But we'll have to pay filing fees and whatnot going forward as well. I'm exhausted, and I'm not giving up the fight for freedom, but I need to know that I'm not alone in this fight. It would be nice to know that you guys appreciate the fight that I've been doing, appreciate how I've been trying to educate the public on the law and the Constitution, and giving you things like the mobile app for the Michigan and U.S. constitutions, or creating that social media platform with our tech extraordinaire who created We the People, so you can go on there and have social media free of censorship as an alternative to Facebook or other social media. That we have all these other projects in the works that are still in the works and are coming as soon as we can get through some of these other challenges that are currently in front of us. So help us in any way that you can. Pray, please pray. Pray for peace for my family. Pray for the truth and the Constitution and the rights that God gave each of us to reign and to win in these next few days. Pray for my safe travels to the trial, and pray that the freedom fighters can begin to work together if they have not, to continue working together for those who already have. It takes a team, it really does. And although people like Rick Martin and myself have not had a chance to have too much of a sit-down chat, his heart is in the right place. People like that, we need to come together. So we need to be careful about things. I've made a video, for example, on the newest Stand Up or Unlock petition and where that's at. I think the people Stand Up is, their heart is in the right place on trying to fight for those things. But we need to still be speaking the truth and not sugarcoat, but we definitely need to support each other where we can. And so with that, guys, I still owe you a video where you guys can answer, or excuse me, ask me any kind of constitutional questions. And I will do that very soon. I'm not sure when. If I get a chance, then maybe today or in the next couple of days. I most likely will also go on and do another video to explain what some of the legal issues really are in the case. And if you guys want to come prepared with questions regarding that, that'd be great. I would love to have your feedback, and maybe you guys can help me clarify what some of my arguments are that I think are clear that need to be better clarified and that kind of thing. So with that, guys, again, I just ask you for prayer. Keep tuning in, keep following our channels on Rumble and on YouTube and Facebook, and we hope to see you soon and to hear from you soon. And if you have reached out to me and you have not heard back from me, please know that I am still inundated on a regular basis. I'm not ignoring anybody, and I am trying very hard to get caught up. Some of you have been waiting a very long time to hear from me. You're not ignored. Your questions, like my friend Robert Bose, and his uncle's question on taxation is, they're still important questions, and I'm going to get to them. But please know I am one person and don't have paid staff, and I've been doing all my freedom fighting for everyone's rights for free. And so any help that you guys can do would be great. Any patience you can extend or any grace you can extend towards me and the efforts that I'm making would be greatly appreciated, as well as your thoughts and prayers. So, and yes, those of you who know about our family selling our house, we are relocating, but whether I'm in Michigan or not does not change the fact that I am a licensed Michigan attorney, and I am going to fight for freedom until the day that I die. So you have not lost a freedom fighter in any of my recent circumstances, nor will you. I will always be fighting for our freedom. And I was born in Michigan, and all but one of my kids were born in Michigan, and my parents were born in Michigan, and my in-laws were born in Michigan. Michigan is our home. But it's time for our family. It has been time for our family to move on with the plans that we made years ago, once our 3 older kids were out of high school and turning 18 or 20, as the case may be. And that's where we're at. So again, guys, I will see you guys later for another video, and I wish all of you the best and hope that your day started a little bit better than mine. All right, everyone, thanks.